right, good afternoon.
Hello, Your Honor.
Afternoon.
Hello, Your Honor.
Hello there. Do we have everybody on the Zoom hearing who we're anticipating would be appearing this afternoon?
I believe so.
I believe so, Your Honor.
Okay, all right, then I'll go ahead and call this case at this time. This is cause number DC 20-04749, Elijah Meek and Katrina, is it Seth Maury versus EPSI Inc. and Stephen Collins. It's set today for the defendant's motion for an amended trial scheduling order. Is that correct?
Your Honor, Luke Bickham for the plaintiff, and that is correct insofar as the defendants filed a motion for entry of a docket control order, as did the plaintiffs. So we have one as well.
Okay, so they are two orders, and I guess we will go with, let's see here a moment. I guess let me figure out who is going to tell me what is the sticking point in terms of the amended scheduling order. What is different between the two, or what is it that the parties cannot agree upon?
Your Honor, I can run you through that if you'd like.
Okay, that'd be fine. Is that Mr. Bayman? If you'll go ahead and announce on the record your name and who you represent.
Yes, Your Honor. Maxwell Bayman of Hermes Law, appearing on behalf of the named defendants.
Right.
That would be EPSI Incorporated and Steve Collins.
Okay.
Your Honor, may I have permission to share my screen to
Yes,
show you
you
the
may.
competing orders?
Yes, you may.
Let me pull up screen 2 here. Okay, Your Honor. So we have the plaintiff's order. And there were just
I'm sorry. 1 second. I think the YouTube link is doing that. He's going to have to get out of the, can you get out of the share screen real quick?
Yes.
Okay.
Oh my goodness. Sorry. It rarely does that. Okay.
Is he able to share the screen, Mrs.
Yes,
Ruth?
ma'am. I turned it on.
Okay.
Okay.
All right.
Let's try that
Mr.
again.
Sorry about
Okay,
that,
so I
Mr.
will go ahead
Bayman.
and
Go ahead.
yes, Your Honor. So the sticking points that I've seen for plaintiff's order between his order and my order fall on numbers 5, 6, and 8 of his order. So this is the proposed order by the Mr. Bickham, by plaintiff's counsel. And the issue I had here with number 5, that's the deadline for joining additional parties. And the one issue I have with this is that to me it was a little ambiguous if this covers just Rule 37, 38, and 39 regarding additional parties, or is this also covering Chapter 33 with respect to the designation of responsible third parties? So I think and I'm not entirely sure, but that's one issue that I would like to clarify. The other, dealing with number 6, is the deadline for amending and supplementing pleadings. Now, the deadline proposed under number 6 is just 2 weeks before the trial date. So trial is August 16th, and this deadline is August 2nd. The problem with it being 2 weeks before trial is that it becomes impossible for me to conduct any discovery on any new claims that have been asserted. That's in part because if I serve any request for production, interrogatory, or request for admission, I have to do so at least 30 days before the discovery deadline. Well, the discovery deadline fell under this order on July 16th. So that's in number 3 here, but it fell a few weeks before the deadline for amending or supplementing pleadings. So we are kind of locked in to a potential situation where we may have trial by ambush on a particular claim. The last issue that I saw with this was number 8 with respect to the dispositive motions. So number 8 at first sight seems like a pretty level-headed order. And quite frankly, I think, to be fair, I think a lot of judges here in Dallas County do endorse this. This is part of the uniform scheduling order that was issued in this case, the filed and heard language. But that's one thing I like to change, because what happens with filed and heard means that as a defendant, we're prejudiced prejudiced in the sense that we don't actually know when our filing deadline is. At first, it seems like it may be 21 days before July 16th. I have run into that issue where we did that, filed 21 days before the deadline, called up the court and asked for an available date. And the court said, oh, I don't have anything for a month and a half. So we, by filing ahead of the deadline, filing by the deadline effectively, we missed the deadline. So it's this big question mark for us of not knowing when we can actually file this motion. And you have to understand, the further we get away from the dispositive motion deadline, the closer we get to the discovery deadline. And that creates issues for us. And tell me if you see this. I've pulled up Westlaw. Are you able to see that, Your Honor?
Yes, I'm able to see it.
Okay. And I'm looking at the motion for summary judgment rule. This is Rule 166A. And so the problem we have is that the Supreme Court, when they endorse this rule, there's a comment that says a discovery period set by pretrial order should be adequate opportunity for discovery unless there is a showing to the contrary. And ordinarily, a motion under paragraph I, the no evidence motion, would be permitted after the period, but not before. And so if we're thinking, oh, we have a no evidence ground, we have to file it during the discovery period and then run the risk that it's easily defeated because the plaintiff inevitably is going to point to this comment and say it's not right. And it to some degree eviscerates our ability to seek summary judgment. So the way we've proposed addressing that is we have pleadings deadline and joinder deadlines in our proposed order. This is, by the way, this is our proposed version of the order. So number 1 and number 2, they put the deadlines on the same date. And the reason for that is because the rules, Rule 37, which I'll pull up for you, already endorses the addition of parties, but it can't be done at a time or in a manner that would unreasonably delay trial of the case. So it needs to be sufficiently far in advance of the trial date. Here, we've done it 4 months before. If you're going, joinder, 4 months before. If you're going to join parties, we might as well close up the case too in terms of pleadings, so we have enough time to conduct discovery on those claims. Plaintiff's expert designation would fall a week after that, and then 30 days later, we would have defendant's expert designation. So it's not favoring defendant or favoring plaintiff really in that regard. And to accommodate, we have, because of the way the expert deadlines fall, we actually extend discovery specifically to experts past the proposed discovery deadline to give a full 30 days to conduct depots after we designate. Otherwise, if we put on the same deadline, that would leave roughly 2 weeks to get depots done, or roughly 3 weeks, which would be very hard to do under most circumstances with coordinating schedules. So that's why we have the different discovery deadline. The dispositive motion deadline is the same, but we took out the and heard language, so that way it can still be taken as a pretrial matter at our pretrial if necessary, because of scheduling conflicts between opposing counsel and your docket, Your Honor. So those were, in a nutshell, those are the primary issues that Mr. Bickham and I just couldn't reach an agreement on. And again, I think that the order we're proposing, I can't really point to one thing and say, okay, it's defense friendly with the exception of the dispositive motion deadline, but that's just intended so that we actually know when we need to file it. And we have a concrete deadline in that sense, Your Honor.
All right, thank you. Mr. Bickham?
Certainly, Your Honor. And since we started, I guess, with plaintiff,
You're cutting out.
the motion deadline, and can you hear me okay?
Yeah, it delayed a little bit, but we're able to hear you now.
Okay, sorry. I was going to start with number 8, which is the dispositive deadline
Okay.
that Mr. Bayman talked about. So I have no objection to having the deadline to file the motions for summary judgment or other dispositive motions on the 16th and have them heard later. What my office had done is simply take the model DCO and insert that. And I have done that both ways. So I have no problem with having the deadline to file it on July 16th and the deadline to hear the motions at some later date. So I think that will clear up any issue there.
Sorry about that. It delayed for me again.
Okay.
The last thing that I heard you say, Mr. Bickham, was that you have no objection to the dispositive deadline that's indicated in number 8 of the order, that you have typically used the language provided by the DSO order.
That's correct, yes. And so what we did is simply use that language in our DCO, but I have no problem with using Mr. Bayman's DCO for that point where you have the deadline to file the motion, the dispositive motion on July 16th, but that it can be heard at a later date. And I think he uses August 2nd or at pretrial. So I have no objection to that issue.
Okay.
Really, the two main issues for me involve, and this is on the defendant's amended scheduling order. One is the pleading deadline. And I'm a little bit confused by the model order from the court, because the court in their model DCO has 120 days prior to trial as your pleading deadline. And then there is another deadline 45 days prior to trial. And in the defendant's proposed DCO, they have it on April 23rd, which is 113 days prior to trial. Now, Texas Rule of Civil Procedure 63 allows a party seeking affirmative relief to amend their pleadings up to 7 days prior to trial without leave of court. Now, obviously, the court through a DCO can change that. What we have here, Your Honor, is an automobile collision. And my concern about having a pleading deadline 120 days prior to trial is that if I were to conduct some discovery, or for example, I'm deposing an expert, and that expert says, well, I talked to some witness that I haven't spoken to, and he said there was a problem with the defendant's tire. And I haven't alleged that he was driving his vehicle while he had a defective tire on. But I don't find that out until I depose the defendant's expert on July 15th. Well, then under the scenario of defendant's DCO, I have to then file a motion with the court to then amend my my pleading because I've passed my deadline. That can be remedied logistically if we just allow the plaintiff to amend his pleadings closer to trial once the discovery period is over. I just think logistically that makes more sense than putting it back 4 months prior to trial. So that's kind of my position on the pleading issue.
Let me ask you this, though, with respect to that scenario that you just offered the court, with this being an automobile accident, and you might find out sort of late in the case that there's an issue with a tire. How is Mr. Bayman able to conduct discovery on that issue that you might find out late in the game, if you will, about once discovery has already closed? I think that was the issue that Mr. Bayman was offering to the court. And I don't want to speak for him. I'll let him respond to that. But I guess, how is he to do discovery on an issue that you may amend your pleadings for?
On a specific allegation such as the one you're talking about?
Correct.
Well, that was a kind of a situation where that would be something I learned from the defendant in, for example, his expert witness. So he would already have knowledge of that. Obviously, if it was something that I learned about and then added it into the petition late in the game, in that scenario, I think he could do one of two things. He could either request a 60-day continuance and then say, we need to do discovery on this new allegation, or the court could allow him to do some discovery within the discovery deadline, after the discovery deadline. I think that's going to take care of those two scenarios.
All right.
Your Honor, would you want me to respond?
Yes, if you could just respond to that particular issue.
Sure. I think I understand Mr. Bickham's argument, and I could say, well, really, it's 6 and 1/2 a dozen in the other, right? At the end of the day, somebody files a motion, somebody argues good cause, and then the court weighs the issues and makes the determination. It's just a matter of who does it. With our order, though, I don't think we fall into that situation of either one of us drafting pleadings. The amendment deadline falls far enough in advance that he would be able to, it's an automobile accident case, right? This isn't some crazy case, but he would be able to clearly outline all of that, unless he's thinking products liability with a defective tire or something. He'd be able to outline the core cause of action. So if the failure to maintain on my part still falls under his general negligence pleading, and under his scenario, we would have already had notice of those facts anyway. This gets us those pleadings in time, those causes of action in time, so we can conduct discovery on them, both him and me. He has the same concern with defenses. If I raise a defense, let's say we're premises liability and I raise a Chapter 95 defense because he's got a subcontractor that he represents. Well, if I spring that on him last minute, he's not going to like that. So it works both ways. He wants to conduct discovery on my defenses as well. And that enables us to do that and significantly reduces the likelihood that either one of us has to file a motion with the court for a trial amendment or to extend discovery. If there's some kind of bad play, right, I've hid the ball on him from certain facts, he could get a trial amendment for good cause on that. And then as punishment, the court could limit my ability to conduct discovery on it, I guess. But I'm just trying to think, progressively on this. I think that bottom line is if we can do it early enough, it really makes it a moot issue, especially on a MVA case like this.
All right, Mr. Bickham, if you would let the court know, in terms of the amended scheduling order 5 and 6, what are the dates proposed by your particular order?
Certainly. Let me pull that up real quick.
Okay.
And
Because
I'll share
I understand there wasn't a problem with number 8, the dispositive deadline. Is that correct, Mr. Bickham?
That's right.
Okay.
And I'm pulling up to share my screen.
Okay.
With you. Yeah. Do you see that?
I do.
Okay, so this was my proposed docket control order that was sent with my motion. And so I had on, and you said 5 and 6.
5 and 6, yes.
Okay. I had, and there's a typo here. This was supposed to be August. Hold on.
August 16th?
No, just a minute. There was a
Okay.
mistake here made.
I think you wanted to be August 2nd. Is that what you wanted?
Well, no. For 6 and 7. So you said 5 and 6, but on me, 6 and 7 are my 5 and 6. I'm sorry.
Okay.
So my deadline was August 2nd for the plaintiff to amend or supplement the pleadings. And then the deadline for the defendant to respond to those was August the 9th. So that was the difference between his 5 and 6 and my 6 and 7 was he was recommending April 23rd as the deadline for me to amend and supplement. And I would agree with Mr. Bayman in that the primary allegations have already been made. I've alleged negligence against the driver. I've alleged respondeat superior against the owner of the company, as well as negligent entrustment, kind of those basic negligent allegations. I'm worried about, in my general negligence, if I want to add some little issue about, he crossed the yellow line or, something smaller like that. That's what I'm concerned about. I haven't already alleged my basic negligence allegations. I have. I'm worried about those little things that you find out by some random deposition, whether that be an expert deposition or some random fact witness. That's what my concern is, putting it so far back into the year.
Okay. All right. Counsel, is there anything else you'd like to add before we conclude this hearing? And I want to make sure that I do have both orders have been uploaded. Can counsel confirm whether or not both orders have been uploaded or filed with the court? Yes.
Your Honor, Luke Beckham again for the plaintiff. We filed our motion either the same day or the day after Mr. Bayman filed his motion, and attached to my motion was my proposed docket control order.
Okay,
And I will say that there was another sticking point
okay,
that Mr. Bayman talked about that I'll just briefly touch on with the judge. First of all, in reviewing Mr. Bayman's proposed docket control order, I don't really have an issue with the expert designation dates, and I believe he has April 30th for plaintiff and May 31st for defendant. Mine was only 2 weeks later, so I can make that work. My issue was the discovery deadlines of his DCO, which I believe he had 2 different discovery deadlines. He had one for fact discovery and then a second for expert discovery. What I had proposed in my DCO was to just have a drop dead discovery date of 30 days prior to trial. So I had my discovery deadline is July 16th, whereas Mr. Bayman had fact discovery deadline on June 18th with an expert discovery deadline of July 2nd. So that is our other, I guess, sticking point.
okay. All right, counsel, did you want to speak to that other particular issue, whether or not there should be 2 different discovery deadlines, one for fact discovery and one for expert discovery, or whether or not there should be one?
Yes, Your Honor. Max Bayman for the defendants here. So I would agree that generally, right, discovery cutoff, it's accepted that discovery cutoff should be 30 days for trial. I've been burned by that comment under Rule 166A before. And so what we do now to address that is we set it 60 days back so that by the time that ends, assuming, let's just say hypothetically, we file our no evidence motion for summary judgment on that day, the hearing on that no evidence motion for summary judgment would occur roughly 3 weeks later, or about 30 to 40 days before trial, falling right within what would otherwise be that dispositive motion deadline. So it gets us to a dispositive motion, at least a no evidence basis, with enough time to have it heard before trial. It also gets us the ability to file that no evidence sufficiently in advance of other deadlines like identifying exhibits, our pretrial deadlines. And I think it falls on the same date as mediation deadline, but we're able to at least have it pending by mediation in theory. With that discovery deadline falling that far, I guess that close to trial, it makes it harder to do that.
Okay.
Your Honor, and if I may just speak on that one issue, if your discovery deadline is July 16th and your dispositive motion deadline is that same day, and if we're going to agree to allow the dispositive motions to be heard up to and including the day of pretrial, or if the court wanted to even hear it at some point during the trial, you can actually still have time to file the dispositive motion, whether that's a no evidence or a traditional summary judgment, or it's a motion to exclude an expert witness. You can do all of that on July 16th. And you will have plenty of time before trial for the court to hear that and decide whether or not, hey, this case is going forward, with trial on the 16th, or whether it's been dismissed or part of it's been dismissed, or whatever the case may be.
Okay. All right. Is there anything further, gentlemen? Anything further that the court needs to be made aware of with respect to the scheduling orders?
No, Your Honor. May I just briefly touch on his response, or do you think you've heard enough and there's no?
You can go ahead. No, you can go ahead and briefly
Well,
touch on that particular response.
Yeah, the only thing is, it's never my intent to file the MSJ on the deadline. In theory, if we did that, if we filed it on the 16th, then I would guarantee that I have to go through the cost of trial prep at that point, because the 21 days places the hearing so close to the date of trial that you're essentially prepping for your MSJ and prepping for a trial. So our goal, of course, is to get it done much earlier, and having that earlier discovery cutoff enables us to do that earlier. Things come up, so we like the deadline to be 30 days out from trial. If we need to bump it forward a little more to put the heat on us to effectively get our MSJs on file, we can do that. But it's not my intent to file it in such a manner that you end up having to hear it at a pretrial conference when everybody's shown up and they're ready to go to trial, and if sunk all that cost. So that's something that I would try to avoid. So if we need to address that issue, we could bump the MSJ date up a little bit earlier to prevent that from to prevent the MSJ on the eve of trial from happening.
Okay, all right. Okay, gentlemen, I am going to take a look at the two orders. I think I have a good grasp of what the sticking points are in your particular order. I will enter an order today. You will know which particular order that I enter because I will email you a copy of the order, the signed order that I do enter. And if I have to interlineate any dates on the particular order, they're going to be contained therein. All right. Is there anything further?
No, Your Honor.
No, Your Honor.
Okay. All right. Then that concludes our hearing. Thank you, gentlemen.
Thank you.
Take care.
Sure.